Good evening, everybody. My name is Mohammed Watam. I'm professor of law, and I will be chairing this session. 2020 has been a very special year, one that cannot be forgotten easily. Put otherwise, it has been a year to be remembered for many years to come. Among many other fields in society, COVID-19 has challenged the legal field almost in every single jurisprudence, such as constitutional law, criminal law, medical law, the law of contracts, tort law, and international law. It gives me great honor to chair this panel on international law and COVID-19. At this panel, we are privileged to host three distinguished speakers who shall in turn elaborate on several aspects of international law in relation to COVID-19. Professor Eyal Benbenisti will assess the reflections of the WHO to the COVID-19 pandemics. Attorney Gilligan Moore will discuss queries related to the protection of human rights in the context of surveillance and COVID-19. And Dr. Renana Kidar will cope with questions concerning fake news, social media, and COVID-19. Allow me, please, to introduce in a nutshell our three speakers. Professor Eyal Benbenisti is a professor of international law at the University of Cambridge and the director of Lauterbach Center for International Law. He is the recipient of several prizes, including the Humboldt Research Award and the Frank Deeg Prize. Attorney Gilligan Moore is the director of the Social and Economic Rights Unit and of the Right to Housing Program at ACRI, the Association of Civil Rights in Israel. He received his LLM in International Human Rights Law from the American University in Washington, D.C. in 2007. And finally, Dr. Renana Kidar is a senior lecturer, assistant professor of law and the digital humanities at the Hebrew University of Jerusalem. She is a member of the Young Scholars Forum at the Israeli National Academy of Sciences. She holds a degree in law and political science from Tel Aviv University and a PhD in comparative literature from Stanford University. Without further ado, I shall invite Professor Benbenisti to open this session with his lecture. Each speaker will have between 12 to 15 minutes so that we will have some time for Q's and A's. So please, Professor Benbenisti.
Mute myself. So thank you for the opportunity to share with you kind of assessment of the WHO's performance during the recent pandemic. It's actually more than a year now. And I will start by looking at the timeline of COVID-19, beginning in early December 2019, around 8 or 10 of December. First symptoms of pneumonia of unknown causes appear. It takes till the end of September for a company in Toronto, a private company called Blue Dot, to identify an epidemic in Wuhan. Blue Dot works on analysis of social media through AI, and they are the first to announce to their service that there is a pandemic going on. At the same day, the Wuhan Health Commission declares that the disease is preventable and controllable. Another week passes. On the 7th of January, the Wuhan Institute of Virology isolates the genetic sequence. And then 2 days later, China and the WHO announce a new coronavirus. It takes another 2 days for the Wuhan health centers to release the draft genome of the new coronavirus. This is exactly the day that the the effort to develop the vaccine starts with the draft genome, there is now a possibility to start working on the vaccine. Now, around mid-January, there's a People's Congress in Wuhan, and the Wuhan Health Commission issues daily updates saying that no new cases of infection, no firm evidence of human transmission, no infection of medical workers. And the WHO accepts that and echoes this information. The Director General of the WHO set up a field visit to Wuhan. It takes two days, and then the following day, when Wuhan shuts down, the emergency committee of the WHO starts debating whether or not there is a public emergency and whether or not to declare what is called FAIC, which is Public Health Emergency of International Concern. On the 22nd, the first meeting, they decided there's not enough evidence for that. So they reconvene on the 30th of January, when there are already 83 cases in 18 countries reported, when they recommend that the Director General issue a FAIC, which he does. Now, in the statement, the committee applauds the Chinese government, welcomes the leadership and the political commitment of the very highest level of Chinese government, their commitment to transparency, and the efforts made to investigate and contain the current outbreak. China quickly identifies the virus and shared its sequence so that other countries could diagnose it quickly and protect themselves, which has resulted in the rapid development of diagnostic tools. So you ask yourself, what is going on here? It turns out that off the record, the WHO officials tell that they are frustrated by China's delayed releasing of information. They say that the Chinese government only released the genome after another lab published it ahead of authorities on a website, as we saw on January 11, and that even then, China stalled for at least 2 weeks more on providing WHO with detailed data on patients and cases, and the WHO officials were lauding China in public because they wanted to coax more information. Privately, WHO officials complained China was not sharing enough data. There's a trade restriction based on the current information, and requests countries that they inform WHO about travel measures as required by the international health regulations. Countries are cautioned against actions that promote stigma or discrimination. So, in other words, by the time that Wuhan itself is under lockdown, the WHO does not recommend any restrictions, and in fact, asks states to act in a way that allows travel to continue. I jumped to May 2020, when the US ambassador in Geneva approaches the Director General of the WHO and issues an ultimatum, ultimately, of 7 demands that test the independence of the WHO from China. The US requests an investigation of the handling of the COVID outbreak, requested the WHO to call on China to produce live samples, to support travel restrictions, to dispatch teams to study responses in Taiwan, namely not to ignore Taiwan, and other demands that it takes only several hours for the Director General to simply ignore. And therefore, President Trump announces that the US withdraws from the WHO. Now, what happened? How can we explain the change, the shift of the WHO from a US-led organization, this is how it started, to an organization that is dependent and is partial to China? I have no time to go into the details, but we can see, we can trace the evolution of the WHO from a Western institution that succeeds in putting the Soviet Union aside, using family planning as a health issue to combat communism, to a body that since 2006 is influenced increasingly by the South and specifically by China. So since 2006, China decides who is going to be the Director General of the WHO. And in fact, we can say the writing was on the wall, or in previous pandemics, since the very successful treatment of the SARS pandemic by the WHO in 2002-2003. Since then, every pandemic met a WHO that is incapable of responding effectively to the crisis. And repeatedly, review committees post the 2009 and 2014 pandemics stated that the world is ill-prepared to respond to a severe influenza pandemic or to any similarly global, sustained or threatening public health emergency. We could, in the Q&A, discuss the reasons for that. I'll be very brief here because of lack of time, but I just want to end by still pointing out to three positive elements that we can see this year developing under the auspices of the WHO. First is the COVAX, the COVID-19 Vaccine Global Access Facility, which enables the private-public partnerships to seek to fund and to procure and disseminate vaccines to developing countries. And a recent update is that COVAX managed to secure at least 1.3 billion donor-funded doses of vaccines, not Pfizer or Moderna, which cannot be transported to developing countries, but AstraZeneca's and possibly also Johnson & Johnson's, to reach 92 low and middle income economies during next year. So ultimately 2 billion doses that would suffice for 20% of the population by the end of next year. So this is one positive development. The other positive development is more on the normative side, pushing for a sense of equal provision, equal distribution of vaccines. This is another initiative of WHO, of the Strategic Advisory Group of Experts, referring to, among other considerations, equal respect and global equity. And finally, an attempt to nudge individuals by convening a technical advisory group on behavioral insights and sciences for health, which is designed to implement policies and programs to study and shape individual behavior. So maybe here's an idea of trying to pass by governments, evade governments, circumvent governments, and address specifically individuals, helping us to decide on our own whether we want to have masks or not, and how to secure our health and other people's health. So this is what I could deliver in almost 12 minutes. Thank you very much.
Thank you very much for being so punctual. It's not by chance that you teach in England. It means a lot. So our next speaker is the attorney Gilligan Moore, who will be speaking about human rights, surveillance, and COVID-19. Please, the stage is yours.
Thank you, Mohammed, and good evening. Well, 2020 was a very challenging year for all of us here at the Association for Civil Rights in Israel. The government and the Knesset used extreme measures to slow the pandemic and protect public health. The amount of decisions, the severity of them, the pace, and the fear from the virus all created an alarming situation. If that's not enough, all of you probably remember that all happened in the midst of an ongoing political crisis. So we have worked harder this year than any other year, I guess, just to show you a little bit the amount of work that we had. Only regarding the government response to the pandemic, we sent 200 letters and position papers this year and 16 legal cases. However, the case that received the most attention in the international community was, without a doubt, the case against the decision of the government to use the Israeli Security Agency, the ISA or Shabak, Shin Bet, for contact tracing. So how it all started? On March 15, in the middle of the night, the government decided for the first time to use the ISA and its mass surveillance tools for contact tracing.
Gil, we hear an echo.
I don't think anybody here is watching.
So if you, okay, so I'll make sure.
I'm alone in the office. So on March 15, as I said, in the middle of the night, the government decided for the first time to use the ISA and its mass surveillance tool for contact tracing. This was and still is the only decision of its kind in all democratic countries confronting the virus. Since infection of COVID is transmitted through droplets and the virus is passed through close contacts between people, when a patient is detected, an epidemiological investigation is undertaken. So the Ministry of Health attempts to obtain as comprehensive information as possible about the patient's close contacts with others in order to determine who had contact with the patient that could cause infection, and to isolate such people rapidly from the society in order to cut the chain of transmission. So why the ISA? Why the Shabak? The ISA is a secret security body that operates under the terms of the ISA law from 2002. It has received powers and effective operational tools for executing its missions, and particularly for preventive security tests. Among other powers, the ISA holds far-reaching powers for the collection of information, including the authority to receive communication data from the communication companies in Israel. Section 11 of the ISA law established that the Prime Minister is entitled to order communication companies to transfer their communication data to the ISA, all of this done without any transparency. Once the information has been transferred to the ISA, the use of it requires only a permit from the head of the ISA. Indeed, Section 11 of the law created what we call a tracing monster that we now assume none of the members of the Knesset imagined when they were discussing this law. An article published on the end of March in Yediot Aharonot described the way in which the powers that embedded in Section 11 have been implemented over the last 2 decades. According to the report, the ISA enjoyed direct access to database of all the communication suppliers in Israel. It continuously and regularly stores the communication data and other personal information of the entire population of the country. This has led to the creation of an enormous database known as the tool. And it's intended to allow the use of the information to prevent terrorism or subversion. Attorney Eli Bachar, the former legal advisor of the ISA, discussed this database in his book, which was published recently. He criticized the fact that the types of information that the companies are required to transfer to the ISA are specified in untransparent rules rather than in the law itself. According to Bachar, this includes location data, subscription data such as name, address, identity number, details of means of payments, and so on, and transmission data, which means the type of message transmitted, the source of the message, its destination, path, and so on. So these abilities that the Shabak has explain the appeal of the ISA for the government for executing contact tracing. Indeed, every citizen in the country has discovered in this year that the ISA is capable within a short period of time of knowing not only where they are at a given moment, but also where they were at any given moment in the past, with whom they met, for how long, and so forth. So basically, the government authorized the ISA to undertake the mass and ongoing surveillance of the citizens of the states and to direct tracing tool that was created and intended purely for the security purpose in order to assist the implementation of epidemiological investigations as part of the attempt to confront the coronavirus. So what was the legal basis for that? So this is a long story. When the ISA was first authorized in March, this was implemented through emergency regulations. The government then was a caretaker government. The newly elected Knesset was not functioning because of the political crisis, and there was no parliamentary oversight. Since the declaration on state of emergency in 1948, as all of you know, it was prolonged and never been canceled. So the government has the power to use emergency regulations that can change any law. This is, of course, a very dangerous and undemocratic tool, but the caretaker government did not hesitate to use it to bypass the Knesset until a new government is formed. We filed the first petition to the High Court of Justice just a few days later, and the court invited us to a quick hearing. The first decision of the court was to force the government to form a temporary committee in the Knesset for oversight. So when the government saw that the court is concerned of the use of emergency regulation, it changed course. And then it used the procedure established in section 7b6 of the ISA law. According to this section, the ISA can be authorized by the government to pursue an activity in another area as determined by the government with the approval of the Knesset subcommittee, if it's intended to protect and promote vital national interests for the national security of the state. So we argued that the crisis is a civil crisis, that contact tracing has nothing to do with the national security of the state, and that the use of and that the use of the ISA for this mission is a very dangerous precedence and a slippery slope. We argue that once you allow the government to use this very powerful tool against the civilians in a civil context, we will not be able to put this genie back in the bottle. We will get used to it. We argued that the alternative is to expand the number of contact tracers in the Ministry of Health, and in addition, introducing a voluntary contact tracing app. On April 26, the court accepted the petition, ruling that it would not be possible to continue the use of the ISA on the basis of the government decision beyond April 30th. And that if the government wish to continue to using the ISA tool, a principal legislation is required. The decision is very important in limiting the ability of the government to expand the roles of the ISA without transparency. It's important in narrowing the definition of the phrase national security, and it's important in emphasizing the importance of the legislative process when basic rights are on the line. So the court also stated that the right to privacy must be kept, that the government must search for civil alternatives, because using the ISA tool, and I'm quoting President Chayut, is a step that might cause any lover of democracy to lose sleep. So now we move on for July 20, as the second wave started. The Knesset quickly passed a new law in the form of temporary order for 6 months to allow the ISA to resume its actions. Since the ISA tracing actions were resumed on July 1st, listen carefully, 1 million people received a text message from the Ministry of Health ordering them to start home quarantine for 14 days based on the tracking of the Shabbat. About 50,000 of them were later found positive. So we are talking only about 5% of the contacts that led to infection. This means that the tool is far from accurate. I'm not even sure if we would have get a much different result if we just check a random group of 1 million people. Another important number, 700,000 appeals were submitted. 412,000 of them were accepted. It's almost 60% of the appeals. So as you can see, this law caused not only a severe violation of the right to privacy, but also a severe violation of our liberty, freedom of movement, and many other rights that were violated because error and unjustified quarantine orders. And soon after they resumed the operation of this tool, polls showed a 20% drop in public trust in the Ministry of Health. The chilling effect was also clear. People thought twice whether to attend a protest or meet family members, even if they followed the social distance principles and wore masks. They were just afraid to get an SMS and be quarantined without a good reason. So quickly after the law was passed, we filed a new petition to invalidate the law or the decision based on it. Unfortunately, the court was reluctant to hear it at the beginning. At first, the court used the fact that the law was amended 3 weeks after it was enacted to reject the petition and force us to file a new petition instead of just let us amend it. When we filed the second petition, a new petition, the court decided that we had to present our arguments to the government before we can file the petition, and that the fact that we were presenting it during the legislative process was not enough. This was another decision that we obviously didn't like. And finally, last September, we filed the third petition that was finally heard on October, and in November 17, we finally got an order nisi in this petition. So the court ordered the government to explain why the use of the ISA tool should not be limited only to cases of people that refuse to cooperate with the epidemiological investigators. In addition, the court ordered the government to explain why it stopped promoting the use of the contact tracing app, Amagen, despite a clear section in the law that requires that. The responses to this order nisi were filed a few days ago, and we are now waiting for the decision of the court. So I guess that if you want to know how it ended, you will have to invite me again next year. Thank you.
Thank you very much. Thank you, Gil. Our next speaker is Dr. Renana Kedar, who will be talking about fake news, social media, and COVID-19. Renana, please.
I can't seem to be able to share, Muhammad.
I'm not the one who masters this.
You can now.
Thing.
No, you can.
Yeah, I see. Thank you. I'll just open the slide. Thanks. Hi, thank you very much for inviting me. I hope you all hear me well. So just as the coronavirus pandemic changed every aspect of our lives, it also changed the internet, and in particular in aspects relating to content moderation of user-generated content on social media platforms. So I want to start with the three preliminary remarks just to set the stage. Social media platforms legally and substantially differ from traditional content providers like newspapers, for example, in that the content that they share or that they generate is user-generated content. Usually without editorial discretion or fact-checking, and as such, social media giants such as Facebook and Twitter that will stand in the center of my talk are generally considered intermediaries, providing the platforms for users to communicate among themselves. Critically, and that's another aspect, the digital platforms also differ from traditional content providers in the scale, amount, and volume, both of the users and the content that is generated. Just to give you a few examples, if the New York Times website sees 31 million readers monthly, Facebook has 2.5 billion users monthly. And every single hour within the hour we sit now, 30,000 hours of content are newly uploaded to YouTube. So this massive volume of user-generated content moves us also to another issue, and that's the importance, but also the limits of digital content moderation that will stand at the center of my talk. Very generally, content moderation refers to a set of practices that online platforms use to screen, rank, filter, and block user-generated content. Now, it should be said from the beginning that all digital platforms moderate, whether it's a closed Facebook group with 100 users or if it's the entire Facebook platform, Twitter, whatever it is. The role of content moderation is to decide and shape basically what the online community will see and what also it will not see. And while there is a general agreement that without content moderation, human or machine-made, and I'll touch that in a second, the internet will be a very hellish place. Just imagine what happens if we stop content moderation even for 1 minute in Facebook. Many questions remain in need of debate and perhaps even regulation. What content gets moderated? When is it moderated? Ex ante or ex post the publication? And by whom, human or AI? And in this short talk, I will briefly describe the challenges and the changes that tech giants introduced in the field of content moderation during the corona and under the pretext of corona or in relation to corona. To the coronavirus, of course, and examine some of the potential pitfalls that might, await us as we perhaps look forward to a post-COVID future and a new order in content moderation. So touching back to Eyal's talk, in February 2020, facing the surge in global cases of the COVID-19 virus, Director General of the World Health Organization said that we're not just fighting an epidemic, we're fighting an infodemic. And the Director General referred to the fake news that spreads faster and more easily than this virus and can hamper an effective health response and create confusion and distrust among people. And in an unusual response, online search and social media platforms like Facebook, Google, Instagram, Pinterest, Twitter, TikTok, YouTube, Reddit, and others took firm proactive measures and steps to counter the spread of rumors by users of the platforms. And I'm showing here some screenshots from these responses. These included taking down misleading information about corona. And you can see here on the side some of this information, most famously like drinking bleach, that can immune you from that, of course, by killing you, I guess. It also included the broadening of the definition of what is a harmful content. Okay, so Twitter announced that it's banning any kind of information that contains misinformation about COVID-19 and also content that goes directly against guidance from authoritative sources of global and local public health information. And lastly, it included proactively promoting content from trusted sources such as the WHO and government agencies. So I conducted this search a few hours ago just in order to update the slide. If you search the term corona in Google search engine in Israel, for example, it will yield, as you can see, official and verified information providers such as the WHO, the Israeli Health Ministry website, and local healthcare providers like Maccabi, Clalit, and some news. Now it's news about vaccination. If you had conducted the same search a few months ago, then you would get all the information about how the virus is, contracted and stuff like that. So these examples from the industry, sorry, I'm apologizing in advance. I'm a little sick. Luckily, I'm home and it's not corona. Social media platforms not only took proactive measures to promote verified information like we see here, they also did it in an unprecedentedly transparent way. And I'm showing here from the Facebook page that is constantly being updated with their latest news. How are they updating their policies? What are they exactly doing? What are their measures? Really unprecedented transparency on the side of the social media platforms. Again, also from Twitter, COVID-19, our approach, all these slides were updated from the last few days just to show you where we're standing. So it's all about the vaccines, but you can imagine that it was differently a few weeks ago and so forth. And these examples from the industry giants are being applied in surprising unison also in smaller platforms, more subversive ones like Reddit, or more less political ones, or, more entertainment one like Pinterest. And the decision by the social media platforms to aggressively filter out unfounded medical advice, hoaxes, and other false information, sometimes promoted by the President of the United States, is not an obvious call at all. And in order to understand this, if you want, mini revolution that happened under the pretext or under the guise of the corona or the coronavirus, we only need to look back to the 2016 US presidential elections and to remind us that for years, digital platforms who see their role, as I said, as intermediaries, resisted intervening in user-generated content. Mark Zuckerberg famously and persistently argued that Facebook is not the arbiter of truth. And Facebook really doesn't have to be the arbiter of truth, because under Section 230 of the US Communication Decency Act from 1996, intermediaries are afforded a broad immunity from civil liability for content uploaded by the users. And in the absence of stricter regulation, digital platforms have two main incentives for moderating content. Their business model, which incentivizes them to protect their services from content that will drive away their own constituents, their own users, and the fear from imposed regulation by government agencies. Now, following the 2016 presidential election, following the 2016 presidential election that brought to the fore the concern over political impact of the fake news and misinformation, and you see here both the graph of the rise in the fake news and the report of the commission, the US Congress Commission on the intervention of foreign powers, Russia, in the social media. So we saw also fueled, it should be mentioned, although it's a little off topic, the data scandal of Cambridge Analytica. There has been a rise in the public scrutiny of how platforms make these decisions regarding user-generated contents. Legislators in the US and in Europe responded in calls to regulate and maybe expand or even waive intermediary liability for user-generated content. And the US courts have also begun to pull away from their broad reading of Section 230 and attend more carefully to the ways in which platforms curate, manipulate, intervene, and repackage user-generated content for their profits. So it's safe to say that at the eve of COVID-19 pandemic, content moderation was going through a legitimacy crisis. And I think the most prime example for that is the report or the white paper submitted by Monica Vicker, the vice president of the content policy in Facebook, just on February 18, so on the eve of the global pandemic, regarding regulation of content moderation, really inviting regulators to intervene and to offer their advice to Facebook. And we see how the public scrutiny over content moderation reached a critical mass. Now, cynics among you perhaps will argue that the seemingly altruistic move by the digital platforms to combat disinformation and promote verified, sources and news about COVID is an attempt to counter this, if you want, tech clash and win favorable headlines for very responsible behavior. But it is hard to argue. It is hard to argue against the the importance of curtailing misinformation about sham treatments, hoaxes, and other potentially harmful behaviors, especially when they are endorsed by the US, president and other prominent public figures. Nevertheless, if this role that the tech companies took upon themselves in response to the corona will redefine the new normal, and we should expect then to see proactive content moderation spreading into other content area. And I think that the elections, the US presidential elections of 2020 show exactly how these big social media sites took steps to mitigate election-related extremism and disinformation, culminating in the face-off between Donald Trump and Twitter, and the great migration also to alternative platforms like Parler, of the people from the conservative and right wing. Just to conclude my brief survey of what happened under the corona served as a major catalyst for another key change in the digital platform ecosystem. The move from to relying on machine learning and artificial intelligence, AI tools, to fight misinformation or fake news and other harmful content, in hopes that the fast and automated computer systems can deal with the constant need to scale up operations. And you have here a very elaborate, if you want, flow chart of where does exactly AI can support the algorithm or support the content moderation process. But what is very important to see is that you still have the human part, okay? So you still have here the human, and the green areas are where the parts that can be supported by AI. What happened under the corona, like in many other work sectors or labor sectors, is that the 30,000 content moderators that were hired after or in response to the techlash of the 2016 elections and other changes were sent home because of the coronavirus. And they pushed the industry forward with machine learning algorithms that were supposed to compensate for the loss of human labor due to these restrictions. So in many respects, the COVID pandemic pushed social media companies to experiment in what they long dreamed of, which is using machine learning tools and artificial intelligence and not humans, so basically erasing the humans in this flowchart to police posts. And it should be said that the scale of user-generated content does not really leave much choice, in the sense that humans cannot possibly overcome 30,000 hours of newly uploaded material on YouTube every hour of the day in every day of the week. But what becomes apparent in 2020 under the sign of corona is that solely relying on artificial intelligence is still far from good enough. And the first to admit this were the tech companies themselves. You can see here the announcement by Twitter that says, and I'm quoting here, we want to be clear, while we work to ensure our systems are consistent, they can sometimes lack the context that our teams bring. And this may result in us making mistakes. This referring to the algorithmic content moderation. And indeed, the effects were almost immediate. And while some of these workers were by now returned or brought back to work, Facebook and Google roughly doubled the amount of potentially harmful material that they removed during the Corona times. And this resulted in far more content that being flagged and removed for allegedly breaking the company rules. And some of it is true negative, so content that shouldn't be online, but it's somehow missing the filters. And some of it is false positive, meaning content that is legitimate and legal, but somehow is being removed by the algorithms without much ability to appeal on these decisions. So alongside the risk of more false positive or true negative removals of legitimate content, the algorithm content moderation also shift the weights from the ex post of first publishing the content and then taking it down by flagging it by the community or government officials to ex ante, basically censoring the material so that it never reaches the community, hence taking away the community's agency in monitoring and in a way effectively debating the harmful content. One more point to conclude, algorithm content moderation, as many other processes of algorithmic decision making, is also far less transparent. The black box proprietary nature of content moderation algorithms that are used by the social media and the lack of accessibility to review the data that is removed grants the private companies enormous power to shape the new public square that is the internet. So if I just conclude the implications of the new content moderation order, at the end of 2020, after almost a year of fighting a pandemic and an epidemic, one can safely conclude that the coronavirus resulted in two major shifts in content moderation. The first is the willingness of tech companies, willingness, altruistic or instrumental, it doesn't matter, but the willingness to engage proactively in moderating user-generated content on their platforms. And the second, the way in which the content is being moderated, mainly by AI. When coupled together, these changes contribute to the drafting of a new order in content moderation and free speech on the internet more broadly. And as we hopefully look to a post-COVID future, we need to assess the challenges that this new order poses to basic rights such as freedom of speech, right to information, right to truth, and more. In reshaping what freedom of expression means in 2021, I argue that we should somehow overcome the binary view of two equally harming options. No moderation at all, that, as we said, will mean throwing away the internet as we know it, or wild moderation that is of content that is solely based on the platform's business models, adopting instead a more hybrid model for content moderation regulation. Thank you.
Thank you very much, Renana. Thanks to all the speakers. So far we have 3 questions here, so I'll put them the speakers in order. We start with Maria Baraki.
Yes.
Hope I pronounced that correctly. Please.
Yes, that's the easiest Greek last name, I guess, So my question is for Eyal, and it's about experts. It could be argued that the pandemic to some extent rehabilitated to some extent some kind of faith in expert knowledge, especially after all these years of the attacks against technocratic governance. But I was particularly intrigued by your last slide regarding the WHO and to what extent, if I understood it correctly, there is now a list of experts where they can provide their knowledge about, for example, the usage of masks, if I heard it correctly, that can bypass governments. And I was wondering to what extent you think that this phenomenon or this trend can refuel this demonization of expert knowledge, or nowadays we do have the tools in order to be able to achieve this balance between expert knowledge and this discussion of the anti-elite. Thank you.
Thank you, Maria. This is a really important question. So two parts to that. One part is whether politicians will cede ground for the experts, which is highly doubtful. I don't see any, anybody in the Chinese party willing to accept what these expert bodies try to do in the WHO. So maybe it's just for the time being, letting the experts try to, to play around a bit. But more fundamentally, I don't think that experts have the answers to allocations, question of allocation and priorities. Just yesterday's New York Times had a debate among ethicists and epidemiologists about whom to prioritize in the context of vaccines. And, there were only experts and they couldn't agree on how to prioritize vaccines for COVID. Now, think about how to allocate responsibility and burdens in terms of environmental protection or land use policies. Developing countries have different preferences than countries in the developed north. So these debates will have to have a political solution or any sort of agreement that will be based on expert assessment, but ultimately will require political agreements.
Thank you. Next question is Jeremy Baraka.
Thank you. My question's primarily for Gil, but I would also be very curious to hear any other comments from the panelists, particularly Professor Ben-Venishti might want to make a few remarks. Gil, your presentation was very interesting and fascinating, and particularly in the context of ACRI, which has been very proactive in petitioning the government on its use of emergency regulations and emergency laws throughout COVID-19. I'm wondering whether you could make a comment or say a little bit about how you perceive the High Court of Justice's role during the pandemic. As we know, what we've seen globally and also in Israel is an expansion of the executive. Israel has also been in a constitutional crisis with a political crisis. And some defenders of the court will say that the court is very much the last speed bump in what is otherwise a democratic decline in Israel. Others will say that the court is nothing more than a rubber stamp for the executive and for Netanyahu's cabinet. I'm wondering whether, given how active ACRI has been in its petitioning to the High Court and your involvement in the cases, whether you could offer some remarks on how you perceive Israel's Supreme Court during this particular period of Corona and the pandemic.
You're causing me a lot of trouble here. So maybe Eyal maybe wants to give his opinion, or somebody from the academia. I'm not used to talk about the way the Supreme Court is, I don't know, responding for our petitions. So I prefer someone else might give you his opinion about it.
If you would prefer to comment on your on the judgment specifically of against the Shabak and Ben Meir and your perceptions of the judgment, then I'm happy to hear comments on that. Your which parts of the judgment you thought were favourable or important, and which parts of the judgment were frustrating. If that's more politically appropriate, then I'm happy for you to comment. But I would be still very interested to hear perhaps Professor Ben-Venishti's comment on the role of the court more generally.
I think that as I said before, the decision is important because it's interpreted for the first time the ability of the government to expand the roles of the ISA using this very problematic section 7b6 of the ISA law, and interpreted it in a very narrow way, maybe not as narrow as we argued, but it will still be very difficult for any future government to just secretly expand or giving the ISA another role using this section. And it was also very important the way that the government just, you know, like not the government, the Supreme Court pushed the government to stop using the emergency regulation and you know, kind of force it to bring it for parliamentary oversight. And I think in this point, the Supreme Court understood the political crisis and the fact that the government is maybe preventing the committees from being formed. It is something that is, you know, the first things that the court must do is just, you know, bring it to order. And again, the parts that we didn't really like is that they said that, yeah, the government was right at the beginning to give the ISA this role and to ask the ISA to help the Ministry of Health in contact tracing, because, and the court explained that this is only because in that moment of time nobody really knew what we are facing. It seems like maybe potentially a serious threat to national security. But I think that we are happy eventually with the decision, and I think that the implications of this decision is much wider than just this case. And maybe in a few weeks I can tell you what our next steps will be based on this decision.
Thank you very much. Professor Moshe Hirsch.
I have one question to Rabbi Benisti. What you have said about COVAX and the whole idea that rich countries are going to spend money for buying vaccines for poor countries, is it something that rich countries, they are doing it as a matter of charity, you know, ex gratia, or is it about some moral duty or something closer to the legal doctrine of common but differentiated responsibility? I mean, do we have here some beginning of some legal duty or not? What do you think?
Well, it's a good question. I think that what we know is what we see, and what we see is governments committing, and actually Israel is among them, committing to support, benefiting themselves, but obviously, more importantly, poor countries. Whether they do it out of a sense of moral obligation, I don't know. Hard to say, but I think that several countries have budget for development health in foreign countries, and they do it maybe out of sense of obligation, but obviously with the understanding that it would you know, enhance their position globally as a good citizen, and so you get PR benefits out of that. You create dependency out of that, and you get people voting for your candidate for the ICJ as a consequence, and other good reasons why it's good for you to commit globally. But we lawyers can see that, I think, as developing, emerging practice, seeing commitment out of statements and action as commitment to global solidarity. You can say that people don't, people in the past realize that the use of force, except from self-defense, is just not good policy, or that distinguishing between combatants and non-combatants is a good practice for the military. But then it developed into a norm, and maybe this is the way we should understand what's going on now.
Thank you. Our last question is by Ron David.
Thank you. First, I would like to make one remark that I don't know who said it, but the ISA, they didn't want to, this mission, they didn't want to use the tool for the COVID-19 crisis, but it was imposed on them by the government. But my question is to Dr. Kedar, and I see that almost in the last few months, the censorship of free speech by Google, Twitter, and Facebook they almost are acting as agencies of truth. I mean, it's really amazing how many people that I know, smart people, that are banned temporarily and sometimes more than that from these social media. How do you explain this, that this media that was created to promote free speech and to be almost below or above or aside of governments are taking government policies and are using it for censorship of people?
Thank you very much for this question. It's 7 o'clock, so I think I will not be able to respond to it in the widest possible manner that it deserves. But I think that what I try to do in my talk is to just show exactly how this gradual change happened. And although I was focusing my conversation on my presentation on the COVID-19 and what happened under the COVID-19, I think that by looking at the two bookends that I presented, the elections in 2016, where there was no intervention, which led to really major interference and political influence on the election, some would say, of the fake news and the foreign intervention without any content moderation or any substantial content moderation, and the 2020 election, in which really Twitter has started labeling President Trump's tweets as, requiring more fact-checking and stuff like that, we can really see this change, a really massive, drastic change that is motivated by both responding to market forces and demand from the users. But what I think what is important to ask here is not only why is it happening or how come is it happening, but maybe more importantly or equally importantly is what is the impact that it creates. And I think one of the...
Conformity.
Sorry?
The impact is conformity.
So the impact might be conformity, but it also what we saw with Parler, which might be a curious, an anecdote that will disappear soon. But what we see is the creation of bubbles. So this word, the bubble, the filter bubbles that was used several years back with the personalized news feeds of Facebook and Google and this fear that you only live within your echo chamber, we now see it happening when groups disperse into their own different sectorial social media platforms. And we should ask if that's a good outcome. Each will have their own public forum to debate without the interventions and the regulations of free speech, Or is it a very, very bad outcome? I would like to argue that it is a very bad outcome, because in a way it really reduces the possibility for any conversation. I don't think I have much more time to answer more than that, but I think that would be the debate that we will be having in 2021. How do we do this content moderation? Because it will be done.
Thank you.
Thank you.
Thank you very much. I've been asked, and I'll be doing that happily by the organizers, to thank all the speakers and the chairmen, women as well, for their contribution to this conference. I hope you found it interesting enough, and we look forward to keep holding this event also next year. Hopefully next year we'll be in Jerusalem physically, not by Zoom. Unless you get used to Zoom. So have a nice evening, and thank you all.
Thank you
very much.
Happy 2021.
Very much.